In Gault by Manuel Ruiz. The problem. This all started when a bored 15-year-old boy didn't have any school and made an innocent prank call to his neighbor. Gerald Francis Gault called his neighbor, Mrs. Cook, on June 18, 1964. Mrs. Cook called the police and told them that Gault and his friend made an obscene phone call to her home. Then the cops proceeded to come to Gault's home and take him away without letting his parents know in any way that they have taken him. What didn't help either is that he had previously been on a probation for 6 months. The note shown here is the note written on a piece of paper letting Miss Gault know when her son's hearing was to be held. This is not an official document or notice and had no information about what charges were filed against her son. The Gault side. The Gaunts said that the sentence for their son was too long and there was no requirement for a hearing notice. There was no requirement for a parent or a child to be informed on specific charges filed and brought. They also argued that they had no right to appeal and their son's proceedings were conducted without basic constitutional rights. The woman here shown is Amelia Lewis, who was an experienced lawyer who worked with the Arizona affiliate of the American Civil Liberties Union. She helped the Gaunts in the case of their son against the state. Arizona's side. Arizona said that the nature of the juvenile system was supposed to be informal. They said that their intervention was based on restriction of freedom, meaning that Gault did not have all his rights and freedom given to him. It was in regard for the best interest of the stubborn or disturbed child. They ordered Gault to be confined for 6 years in the State Industrial School, which is a juvenile detention center. Gault's parents filed a lawsuit against Arizona because they thought the state should give their son the same rights as criminal defendants and for holding their son in detention without giving a fair trial. The Superior Court dismissed the case and went straight to the Supreme Court. This man here is Justice Potter Stewart. He is the only justice to be in disagreement with the majority of the Gault decision by the Supreme Court. Supreme Court speaks. The decision was made with an 8-1 rule in favor of the Gaults, taking away jail from detention. Supreme Court Judge Justice Abe Prentice said that neither the 14th Amendment nor the Bill of Rights is for adults alone. There were many rights and protections that Gault did not get, which can change the whole case in another direction. One main thing that he did not get was a fair trial. The one guy who did not agree was Justice Potter Stewart, who said that the whole point of the juvenile system was to take the cases differently than adult criminals. He did not want to go back to the days where 12-year-olds were sentenced to death just like adults. Affected amendments. The 14th Amendment states, "No state can take away someone's life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws." The 6th Amendment states the right to a speedy and public trial by practical and state district. It is not fair unless the defendant has been notified of any charges against them. The right to an attorney and the chance to be faced and cross-examined witnesses against them. The Fifth Amendment states the right to self-incarceration, which means defendants can't be forced to make confessions or testify against themselves.